Hello guys, welcome back to our channel. And our next topic is marriage, Hindu Marriage Act. What is the procedure and what documents required for the Hindu Marriage Acts, and how the registration of the Hindu Marriage Act would be done. I'm starting with the Supreme Court of India in 2006 made it mandatory to register all marriages, which either it is Hindu marriage or either it is Muslim marriage. So in India, a marriage can either register under the Hindu Marriage Act or under the Special Marriage Act. So the Hindu Marriage Act applies to Hindus, where the Special Marriage Act applies to all the citizens of India, irrespective of their religions. The Hindu Marriage Acts provide for registration of an already solemnized marriage and does not provide for solemnization of a marriage by a marriage registrar. However, the Special Marriage Act provides for solemnization of a marriage as well as registration by a marriage officer. So, to be eligible for a marriage in India, the minimum age is 21 years for male and 18 years for females. So, the registrar marriage process is applicable only for the above mentioned age for men and women also. The registrar marriage procedure for lover also remains the same, which we will see in the following lectures. And also we look into the documents, what the documents required for marriage certificates and lots of more. So registration under the Hindu Marriage Act 1955. The Hindu Marriage Act is applicable in case when where both husband and wife are Hindus, Buddhists, Jain or Sikhs, or where they have converted into any of these religions. So the first step in this marriage registration process is to apply to the sub-registrar under whose jurisdiction the marriage has been solemnized or either party to the marriage has been residing. So both partner will need to fill in the application form, sign it and submit it along with the two photograph of the marriage ceremonies, invitation cards of marriage, and also age and address proof of both the parties, affidavits of notary or executive magistrate to prove that the couple is married under the Hindu Marriage Act 1955, and also fit the mental conditions and proof of non-relationship between the parties with a degree of prohibition. So all these documents which I have discussed above should be attested by the gazetted officer, and the parties will have to deposit a fee with the cashier at the sub registrar and attach the receipt with the application form. Once the application has been submitted and the documents verified, the concerned officer will assign a date of registration when the marriage certificate document will be issued. Now, next, a marriage can be solemnized between any two Hindus if the following conditions are fulfilled, which is if neither party has spouse living at the same time of the marriage. Next one is the if neither party is incapable of giving a valid consent to it in the consequences of unsoundness of mind. Now, if the neither of them has been subject to recurrent attack of insanity of. Now, next one is the bride has completed the age of 18 years and the bridegroom the age of 21 years at the time of the marriage. The next one is the party aren't within the degree of prohibited relationship unless the custom or uses governing each of them permits of a marriage between the two. So these are the marriage can be solemnized if the marriage can be solemnized between any of the two Hindus. These conditions are valid if these happen. So now the next topic is the degree of prohibited relationship. What was the degree of prohibited relationship? Before I have started this topic, I just wanted to ask you one question. Like, who does one approach for marriage registrations? I would like to know the answer in the comment box. So please comment down your answer if you have to know the basic conditions which are required, and also I would like to give you answer in this lecture also. So I would go back to my topic, which is degree of prohibited degree of prohibited relationships. So the two individuals are said to be covered under the degree of prohibited relationships if one of them is the lenient ascendant of the other, and the next one is the if one of them was the wife of the brother, or the father's or mother's brother, or the grandfather's or grandfather's brother of the other. These are the degree of prohibited relationships. Prohibited. Or one more thing I have like to add, like, or if they are brother and sister, aunt and nephew, uncle and niece, or children of brother and sister, or of two brother or two sisters. These relationships are prohibited, and if these relationships are built, or they can try to marriage falling within the above category which I have mentioned, will be considered void. And also these have the if these marriage uh, falling, then the exception and the punishment is also there. The exception, the custom plays a very important role here, because if there is a custom governing the parties, so they may marry even if they fail under the degree of prohibited relationships. And also the punishment, a marriage which is solemnized between the both the parties with a degree of prohibited relationship, is considered null and void. And also both the parties of such marriage are liable to be punished within the with a simple imprisonment for 1 month, or a fine of rupees 10,000, or they can do both. Now, solemnization in Hindu marriage. A Hindu Marriage Act 1955, with ceremonies to be followed in registration or of Hindu Marriage Act by the virtue of Section 7. A Hindu marriage can be solemnized under the customary rites and ceremonies of either parties, where the rites and ceremonies included the Saptapati. Saptapati means the taking seven steps by the bride and the groom jointly around the scared fire. And also the marriage become complete and binding when the seventh step is taken. These ceremonies may vary according to the custom and the tradition followed by the parties. Now, I would like to discuss about the Special Marriage Act. This is very different apart from the Hindu Marriage Act. So, the Special Marriage Act applies to all the citizens of India who are any person, irrespective of religion, can solemnize and register their marriage under the Special Marriage Act. So, the person intending to register marriage under this act have to give notice thereof in written in specified form to concerned marriage officer, in whose jurisdiction at least one of the parties to the marriage has resided for not less than 30 days immediately preceding the date of on which notice is given. Now, the Special Marriage Act deal with both registration and the solemnize of marriage. Under this act, certain condition has been laid down under sections 4 of this act, which are considerably similar to those laid down under section 5 of the Hindu Marriage Act. So, according to this act, no religious ceremonies are a prerequisite for a marriage to be complete. So, according to the virtue of section by the virtue of section 4, neither of the parties should have a spouse living at the time of marriage. The physical and the mental capacity of both the party must be as per section required. Also, the age of the party, which is the female has completed the age of 18 years and the male has completed the age of 21 years. So the parties also aren't within the degree of prohibited relationship, provided that custom governing one of the parties permits such as marriage between them. So these are the Special Marriage Act. So now I would like to conclude my lecture, and also a marriage in violation of any of the above conditions will stand null and void under the Special Marriage Act. And for the Hindu, Jain, Buddhist, Sikh marrying with these four communities, the Special Marriage Act 1954 is an alternative to the Hindu Marriage Acts 1955. So, in India, a marriage can either register under Hindu Marriage Act or the under Special Marriage Act 1954. So, the Hindu Marriage Act applies to Hindus, whereas the Special Marriage Act applies to all the citizens of India. Also, the Hindu Marriage Act provides for registration of an already solemnized marriage and does not provide for solemnization, and the minimum age of both parties, male and females, which I have discussed earlier. So these are the points which I've discussed. Uh, the Special Marriage Act, the also so also I would like to ask two to three questions, like what if the marriage is solemnized in Jammu and Kashmir? This is a very important question, guys, so I would like to know the answer in the comment box. And I would also told you about something, give you a basic brief, like if the marriage is solemnized in the state of Jammu and Kashmir, the parties to the marriage are considered to the Indian citizens domiciled in the territory to which the Special Marriage Act extend. That's why. And also I would like to know your point of view, so please comment down on down your answer, and I would like to conclude my lecture. So thank you so much, guys, and please do subscribe our channel Let's Click, and also follow our Instagram page, LinkedIn page, and do visit our website, which is www.lexclick.com. Thank you so much, guys.